Mike, I know you were a police officer for more than 13 years. You're a DUI enforcement officer. And of course, now you're a criminal defense lawyer who represents citizens accused of DUI. I'm sure you get asked all the time this famous question, to blow or not to blow? If someone is pulled over for DUI, and let's say they know they're intoxicated, they know they probably have a high BAC, the officer wants them to take a breath test or a blood test, should they do it? Or do they have a right to say no?
Well, actually, under California law, and it's two-part, I tell people all the time, if you're stopped at the scene and they ask you to take a PAS test, preliminary alcohol screening test, that under California law, you do not have to take that.
Now the PAS test, you're talking about the roadside, the handheld breathalyzer.
I am, and we find a lot of confusion in that regard from people. So what I tell folks is, and whenever I'm talking even to family and friends and people I just come up with in the community, that under California law, you're not required to take the roadside PAS test. But if the officer tells you you're under arrest for DUI, that under California law, you do have to take a chemical test. Normally it has to be a breath test or a blood test. So I always tell people, if you're arrested, submit to a chemical test. And I always urge them to take the breath test over the blood test.
So basically the roadside handheld breathalyzer, you would say, decline to do it. But if you do nevertheless get arrested or taken down to the station, and at that point when they say you have to do a breath test or blood test, then you advise them to take the test.
Absolutely. I tell them that all the time. And one of the reasons is this. If they refuse to take a test and the DMV find they did refuse, or the court finds they did refuse, there is an enhanced suspension period. For example, first time, 1 year. If they have a prior DUI and there's a refusal, it's a 2-year revocation. So there's really strict punishments and harsh punishments if they refuse to take a chemical test.
Now, if a case were to go to trial or a case were to go to court and the person refused to take a test, so there is no BAC, there's no sort of measurement of blood alcohol level, as far as defending a case in court, is that an easier case? Is that a harder case?
It depends. It depends. I hate to give you a lawyer answer, but the truth is it does depend. The jury will look at the totality of circumstances. The DA will talk about a consciousness of guilt. But certainly from a standpoint, with no chemical test, we have a great leeway to argue that our client was not under the influence at the time, their blood alcohol level was not 0.08% or greater, and there is no qualified scientific evidence to show that effect.
Let me ask you, a client comes in and talks to you and says, I got arrested for DUI, I refused to take the test, the officer marked it down as a chemical test refusal, what the DMV calls a chemical test refusal. What can you do at that point? What is the client facing? What's the consequence of that? And what can you do to defend the case nevertheless?
First of all, consequences for a first-time DUI or a first-time refusal is a year suspension of the driver's license. Second time, let's say you have a prior DUI and you have now a refusal, it's actually a 2-year revocation of your driver's license. But what we can do is this. We can litigate that issue at the DMV hearing. We get the police officer there to make sure that he followed all the rules. For example, they have to fill out the chemical test admonition form, which is on the back of what's called a DS-367 or a temporary driver's license. Okay? And they have to read that word for word verbatim, and they have to properly document the responses. They have to give the person a chance to take a test. And oftentimes what we see is people say they don't want to take any test, the cops bring them down to the station for a blood test, and before they actually administer the blood test, the client says, well, I really want to take a breath test, I'm afraid of needles, and the cops say, no, you're jerking me around. It happens all the time, you're jerking me around, we're just taking blood. Well, that's not a refusal. If someone says before they actually force draw the blood or take the blood and says, I want to take a breath test, we'll win that refusal case, and that happens a lot.
So if let's say it's first offense, I'm arrested for DUI, I absolutely refuse to take the tests, and the DMV gives me a 1-year suspension. Can I get a restricted license? Is there a way around that 1-year suspension once it's imposed?
There really isn't. Now, with this caveat, if someone's a minor, someone 18, under 21, they're in school, they may be eligible for a critical need license. It's on a one-on-one basis. It depends if there's no public transportation. But I tell people all the time, refusals, there's no restriction.
So if I was arrested for DUI, I was charged with a chemical test refusal, then I can have this DMV hearing, right?
That's correct.
And you can represent me at this hearing.
Absolutely.
And try to avoid the 1-year suspension.
Yes.
And have you had success in many cases in avoiding the 1-year suspension?
We've had great success, because what happens is police officers, even though it might be a real refusal, they fail to properly document the information. And so we put them through the task, and we can make technical arguments that they didn't meet the requirements under the law. I'm Mike Scaffidi, a retired police officer and now a criminal defense attorney with Schaus Law Group. If you or a loved one are in trouble and need help, call me.